So, for those who don't know who I am, my name is Sean Cottrell. I'm the CEO and co-founder of LawInSport. I'm delighted to welcome to this webinar today in partnership with our friends at the Asser Institute and Sport and EU. For those of you that don't know, I believe we did a fantastic webinar, but that's what people told us at least. We did a webinar around the European Super League and the other decisions that took place in December last year. And the reason why we, from LawInSport perspective, and I'll let the others introduce their organisations in a second, the reason why we're so proud and delighted to be working with these institutions is, like us, we share this view that we try to explain what's going on in the market, explain what's going on these very sometimes inaccessible or difficult to understand issues. And they do fantastic work throughout the year and have done for many years of also trying to help educate and explain and make it more an accessible sector to be in, which is hugely important. But Borja, before we introduce the rest of the speakers, would you like to just introduce yourself and talk about Sport and EU?
Yes, thank you very much, Sean. Good afternoon or morning, wherever, or evening, wherever you are in the world joining us. Thank you very much for providing this platform, Sean. Yes, indeed, my name is Dr. Borja Garcia. I work as a reader in sport policy and governance in Loughborough University, in the United Kingdom, and my academic work is around sport, European Union sports law and policy and the governance of sport. I am probably now, I have my hat off, one of the founding members and board members of Sport and EU, which is the Association for the Study of Sport and the European Union, Sport and EU. It's actually about to be 20-year-old, so it was founded in 2005 by three of us, and now it's got around 700 members, 80%, 75% academics, 25% practitioners, which have an interest in the study of sport and Europe from a multidisciplinary perspective. It's not a legal society, it's not a law society, it brings all the social sciences. For those of you who don't know Sport and EU, we do events, we do joint events. So we thank you, Sean, and LawInSport. We also thank Antoine and the Asser Institute for their eagerness to cooperate with us. I think this is the second of our joint ventures and probably not the last. I could say, Sean, that it was indeed a very good seminar, the one we did in December 2023 of the rulings. And we hope to continue this. So I would like to thank you, Sean, to thank Antoine, to thank Manan and all at LawInSport for providing the technical expertise to do that. And for those of you who are not aware of Sport and EU, we do other type of also seminars, activities over the year, and one conference per year in around July, which I can now tell because, well, it's public, that this next year is going to be at the beginning of July in Naples, Italy. So if you want to visit Naples, the south of Italy, to join us in our conference. For those who are not yet members or don't know the association, just visit sportandeu.com, sportandeu.com. I will later, after everybody presents themselves in the chat. I will put the link in the chat, but later I'll let it go some 10 minutes, and when the chat is a little bit calmer, I will put that link for
Thank you. So for those of you who are just joining us, if you want to use the chat, and thank you for everyone who has introduced themselves. Thank you for buying into the spirit of this initiative. Get to know each other. If you've got questions, and thank you for the person who's already put in a question, which is brilliant. Use the Q&A feature. If you use the chat for the questions, it will get lost. I will try to. So just again to reiterate the format, we're just gonna hand over to Anton briefly to say a few words about the Asser Institute, and then we're going to start the speakers. We'll start for 5 minutes each, and then we'll come to Q&A. The reason being is we're delighted to have our experts with us. They've got unique perspectives. We'll hear those first. It may cover off a bunch of questions that people have, and then we'll come to the open Q&A part. Anton, did you want to say any words about the Asser Institute?
Not much. I mean, I think we should move to the discussion as fast as we can. But just to thank you all for joining. Thank you, Borja and Sean, for co-organizing. And I look forward to exchanging with you on this important judgment.
Brilliant. So thank you all very much. Right, I'm not going to introduce the speakers. What's going to happen is I'm going to go to each speaker in turn. If you could introduce yourself, and then have your 5 minutes will commence after that. Mario, would you like to kick us off? So we've just had this important decision. What's your perspective? And do you want to introduce yourself to everyone?
Thank you, Sean. Yeah, I'm Mario Flores, the ECA Head of Sports Legal. Thank you for having me. Yeah, I mean, I think it goes without saying that initially this decision was received with some concern amongst our membership. It didn't require a lot of reading to realize that changes will be needed. But nevertheless, now when we have more time to analyze it, to make some initial discussion with our members, I think we have come to realize that the changes that are needed do not entail necessarily like the end of the transfer system, as you can read in some places. Definitely not. One thing that I wanted to mention is I think that we have to make a distinction between what the transfer system is and what the transfer market is. Because even if although obviously they are interrelated, I think they are different things. So the transfer market is basically just the market of clubs making negotiation of transfer fees, sell-on fees, any kind of contractual arrangement that they come to each other, right? And those is not really regulated anywhere, right? You don't see in any set of regulations what a transfer fee is. Obviously, we can analyze it from a legal point of view, what they constitute, but nevertheless, that is different. And this is important because, for instance, in the transfer market, you have certain regulations that do kind of address, for instance, 18Bs, right? The TPO, TPI prohibition, those provisions are addressed to the transfer market because it sets some limitations as to what the clubs can agree between each other.
So Mario, just for everyone else's benefit, and I'm sure everyone's well read on this and they've read about it, but when we're talking about these articles, certain provisions, we're talking about the regulation and transfer status of players.
Yeah.
Just so everyone knows, just for shorthand, just in case there's any, I've seen a few students there, they may be wondering where to look. So if you hear people referencing the articles, that's what they're referring to, unless otherwise stated. So back to you, Mario.
Thanks, Sean. Yeah. So now the judgment, I don't think that it addresses the transfer market as such. So I do not see, at least in my point of view, anything that would affect what the clubs can agree with each other, at least directly. Now, obviously, indirectly, they may be some impact, and that is what we actually need to analyze. Now, in terms of the judgment itself, I think what is really important is to mention that it upholds certain principles, right? Because the transfer system is just a conjunction of several rules. It includes the training and compensation, the solidarity mechanism, the registration of players, transfer windows. So the judgment is addressing very specific articles. Now, whether they can have a huge impact or some impact, well, that's something that we can analyze. But for instance, it doesn't touch registration windows. Obviously, it kind of upholds their validity. The number of clubs that a player can play with now in 5.3, that is a maximum of 2 with maximum of 3 of being registered. That is also outside of the judgment. Importantly, sanctions on players that breach contracts, 17.3, is outside of the part of the judgment. So these kind of provisions that also form part of the transfer system are not touched by the judgment, in my understanding. Now, the things that are touched, I think, is also with some nuances, right? I mean, if you read one paragraph of the decision, you can see that 17.1, they fundamentally disagree with how it operates, right? So the method that they can. But it seems to me that the concept of compensation being payable is upheld, right? So that a player that breaches a contract or a club that breaches a contract, they have to pay compensation. That is upheld by the judgment. It's actually recognized. The point of the joint and several liability, it seems to me that the issue that they have is with the automatization of that principle, right? That the DRC or CAS do not have the possibility to analyze the case by case whether that strict liability is warranted or not. But nevertheless, the actual possibility that a new club can be severally jointly liable, I think it's not deemed as unlawful by the judgment. The sporting sanctions on the new club that again are addressed, it seems to me as well that what they have a big concern is on the presumption, right? So on the presumption and on the lack of flexibility as to the number of registration periods, right? So the judgment says, well, the fact that the DRC CAS cannot actually reduce those registration bans is a 2 or nothing, or that there is no possibility or the presumption in itself that the new club has breached contract, has induced the breach, is the part that they have an issue with. But actually, the concept of sanctioning a club that induces a breach of contract, I don't think that the decision goes that far. Now, obviously, in terms of what is it that we can do now, I think what it's important also to mention is that a big overhaul of how the transfer system operates now, I don't think it benefits anybody in the industry, to be honest. I mean, we have to remember that if, let's say, transfer fees will be affected because of this, hypothetically, I mean, this money is money that a lot of clubs survive on. It's money that stays in the industry. So
Mario, I'm just going to pause you there if that's okay.
Yeah.
Just for the reason that we've got our 5 minutes. I'm going to try to be, so we've already agreed with the speakers. So please don't be offended on the speakers.
Maybe I'll finalize by saying that if these transfer fees are heavily affected, players that are actually transferred out of contract, where this transfer fee goes to their salaries, are also getting affected. One last data is, according to FIFA, 80% of transfers are out of contract. So those players, if clubs have a financial damage because of whatever happens with the judgment, the only ones that are going to be affected are the players that are not benefiting from transfer fees, and that the club will have less budget to cover their salaries. So I think a big overhaul doesn't benefit anybody.
Right, great. Okay, so we've got that. Thank you very much, Mario, for giving your perspective in terms of what the practical perspective of the club is. I'm going to come to Sinziana now to provide a bit more of an overview of kind of like this, and forgive me, I probably should have done it the other way around, so forgive me for this, but Sinziana, can you just provide, for those that aren't familiar with this, of the sort of like what is going on in this space from a European law perspective, what's going on from an antitrust in sports law at the moment, and why have we got here, and how do you view it? So you've heard Mario's on the practical perspective from the club. How do you view it when you sort of take a step back? And maybe you could just introduce yourself as well. Thank you.
Sure. Good afternoon and good morning, good evening, everyone. My name is Sinziana Ianc. I'm an antitrust lawyer at Linklaters. I'm based in Düsseldorf in Germany, and I'm also the co-head of the firm's sports sector. It has been quite fascinating to see how the sports industry, which once was considered to be exempt from the application of competition law, is now being reshaped by antitrust consideration. And there is really a flood of litigation going on. And we are seeing the Court of Justice in the EU and the national courts effectively developing a new regulatory framework alongside with the actual regulators, with sports governing bodies. Obviously, it's an exciting judgment from a sports law perspective, not that much from an antitrust perspective. And I think it's let's say, a very traditional judgment that fits well with the classical understanding of EU law and EU competition law. And I also agree with Mario in that it's a judgment that looks at very, very specific aspects of the rules and at very specific scenarios of contract termination as well. And it's also, from an antitrust perspective, a bit of a reiteration of what we have seen in the past. So again, the court reiterates that FIFA is an association of undertakings and that its statutes can be understood as decisions which affect the trade between member states within the meaning of EU law. When analyzing the rules, the court found a particularly damaging restriction, again, for this, let's say, limited scenario of termination without a just cause. And it concluded that it's a restriction by object because it's a generalized and very drastic restrictions which effectively cloisters market and amounts to no poach agreements between the club. And this description as by object is quite important because it means that only certain type of justifications can apply to it. which are the ones described in Article 101 TFU, so the Treaty of the Functioning of the European Union. And in practice, these justification in Article 113, these are very rarely applicable, and the court already hints in the judgment that it does not think that the Belgian court will consider that that this is the case.
And Sinziana, sorry, can you just, again, for everyone's benefit on that point, in terms of, and I think we'll bring this up later though, but again, just in terms of the mechanics of this, in terms of, can you just clarify for people what happens next in terms of going back to the Belgian court? We'll hear a bit more detail about that later, but can you just in terms of the mechanics of how these preliminary rulings work?
Sure. So the point of this preliminary rulings is that national courts should have the opportunity to ask the Court of Justice of the EU for guidance on how to decide cases for which the application of EU law is relevant. So effectively, the Court of Justice only gives an abstract interpretation of EU law. Here, the interpretation is quite precise, but obviously for this jurisdictional reasons, the court cannot provide a definite ruling. And what happens now is that the judgment and the case, they go back to the court in Mons, in Court of Appeal in Mons in Belgium, and they need to take the principles stated by the Court of Justice of the EU and apply it to the case as such, and decide in the case, effectively saying, okay, this compensation needs to be paid in application of the principle of the Court of Justice of the EU. But it's quite clear how that will play out.
Brilliant. Thank you very much for that. Is there anything else you wanted to add? If not, you're perfectly on time.
So what I wanted to say, the ruling also reiterates that the sports governing bodies, they play a legitimate role as long as they exercise their regulatory powers within the confines of EU law. And it also confirms that there are objective justifications on which they can rely. So actually nothing new from antitrust perspective. What I found interesting as well, the court does not discuss the thesis of the Advocate General of whether the Charter of Human Rights should apply to FIFA, which would have been like a completely different discussion, which the court does not go into. And I also think that this very detailed and refined proportionality analysis can provide a very useful framework on how the relevant rules can be adapted. So obviously they need to be like objective, clear, transparent, and predictable. But the court already hints at that they need to be like more specific and take into account the very specific economic and factual situation of the contract termination in order to truly ensure contractual stability. And this might be like a more tailored and transparent calculation of the compensation.
So just because of time, we're going to come up, we can go into a bit more detail in that a bit later on, if that's okay. But sure. Fantastic, thank you. So we've heard from Mario about what the clubs are thinking. We've seen this. What does this mean in terms of broader competition law in outside of sport as well as in sport? And now we're going to hear from Carol on the sort of what happens is sort of on the ground and how you're perceiving it. So Carol, would you like to introduce yourself, and then your 5 minutes will start now.
Hi, I'm Carol Couse. I head up the sports media and entertainment team at Mills and Reeve. I think there's a lot to unpack here. Difficult to do in 5 minutes. I'll give it a go. So I think one thing to note is Article 17 has been in the regulations, or the concept of the consequences of unilateral termination have been in the FIFA regulations for over 20 years. And actually, the concepts in there were prompted by a compromise position which was reached in relation to some historic allegations that the transfer system wasn't compliant with EU law. And so there was a compromise position that was reached in 2001. And actually, some of the key provisions were ratified by the Commission then. So things like the protected period. So that is the first 2 or 3 years of a player's contract. And the concept being that is kind of sacrosanct in terms of how contracts are dealt with. There should be, effectively, the approach has been to date, there should be more punishment for breaches during that period because it's the early years of the contract. Also, there was a ratification of a system of sanctions, provided they were proportionate when there was a unilateral breach, and it referred to financial compensation. And this was all referable to the specificity of sport. And I think there has been a weakening of this concept of sport being specific and sort of having this bubble in which it operates. And I think we're seeing the real impact of that now. So Article 17 applies to both clubs and players. Some of the press kind of commentary around this has all been very much focused on the players, but actually it's kind of two sides of the same coin when you talk about unilateral breach of contract, and there are consequences of that. It could be the club that's breached the contract, it could be the player that's breached the contract. The consequences of this are dealt with in Article 17. It so happens, though, that obviously the Diarra case is referable to the player. I think the Diarra case is quite specific in that it is referable to the protected period, so this period that I've just referenced. And so because of this, Mario's referenced it, sporting sanctions were almost automatic because there was a presumption that there was inducement of breach, and so therefore sporting sanctions would flow both to the new club and the player, and that was deemed to be a bit that would, clearly sort of contradict competition law there. The bit around free movement, I think there has been quite a lot of commentary around that. I think on Diarra, it was quite specific. So there's reference to an ITC, and the ITC is the International Transfer Certificate. You need that for a player to move from one country to another internationally. The Belgian club involved had asked FIFA for an ITC to be issued, but the request was conditional. They wanted assurances that there would be no compensation payable, there'd be no sporting sanctions. FIFA didn't give that, and therefore the ITC wasn't issued. In my experience, even where there's been a breach of contract and there's a case outstanding, provisional ITCs are issued. Players aren't prevented from moving in practice, but the consequences of the breach are then dealt with as part of the case before FIFA and potentially the Court of Arbitration for Sport. I guess one of my biggest takeaways has been the concept of unilateral recruitment of players. And in layman's terms, I would say that's often referred to as poaching of players. So we would say, and it's kind of a foundation, one of the pillars perhaps of sporting regulation is that players shouldn't be poached. There should be sanctity of contract. And actually, the Court of Justice has come at this from a very different perspective. And they've said, you can't prohibit unilateral recruitment of players in this sort of context. So put this in a practical scenario. If, say, Mbappe were under contract at PSG and Real Madrid had poached him, i.e. not paid a transfer fee when he was under contract, the Court of Justice's approach to this is you shouldn't necessarily provide for the consequences of that in your regulations. It's up to the contracting parties to deal with whatever the consequences of that might be. Now, often you hear about kind of buyout clauses, penalty clauses, that sort of thing. I think what's going to happen going forward as a result of this more of a focus on the playing contract and what's contained in that is that there's going to be more work for the lawyers, because these things are going to have to be so watertight to ensure in the event of breach of contract that these sort of, whether it be, penalty clauses as sometimes they're referred to on the continent, contractual clauses that deal with termination of contract, are they watertight? I'd say they'd be my key takeaways.
Brilliant, Carol. Absolutely on time. So thank you very much for that. So for those of you that just joined us late, please use the Q&A feature for your questions. What we're doing is we're going around all the speakers, and then we'll do the open Q&A part just in case some of the things that are mentioned by the speakers cover off some of the questions. There's no point. I don't think there's much point in interrupting them during their presentation. So we've had great insights from Mario, Sinziana, and Carol now. So we've heard from the club's perspective what's going on in terms of trends in sort of EU perspective, and then Carol has just identified sort of key issues that come up in the case about how the history of how the system was established, the compromise agreement. Fantastic. So now we're going to come on to Pieter, who was involved firsthand in the case. So Pieter, would you just like to introduce yourself, and then I'll start your 5 minutes.
Thank you, Sean. Good afternoon, everybody. My name is Pieter Paepe. I'm a lawyer based in Brussels. I'm a partner with Edson Legal, and I represented FIFPRO and UNFP, so the French player unions, in the Diarra case. And in my 5 minutes, I would like to make 2 short observations. And the first one concerns worker protection. And I believe that the Diarra judgment shows a deep distrust by the Court of Justice on how FIFA is regulating football. And that distrust was very clear in Super League and in Royal Antwerp, and the Diarra judgment is a continuation of that distrust and the lack of confidence in how football is regulated. Super League, Royal Antwerp, Diarra all say that associations such as FIFA can, in principle, adopt rules on the organization of football and on participation by clubs and players in competition. But in my view, the Diarra judgment goes one step further. And I really believe that this is a key point. And the court suggests in point 99 that FIFA is not the appropriate body for regulating worker protection. Worker protection is absent from the statutes of FIFA, and there is no government that has entrusted FIFA with the responsibility to issue rules on worker protection. And that was also a central argument of the unions before the Court of Justice. The regulation of worker protection and employment law should be in the domain and is the privilege of lawmakers and of social partners. If this is not regulated by the lawmakers, the social partners should step in. Workers, players, and employers' clubs should negotiate collective bargaining agreements. And before the Court of Justice, we also argued that regulating football does not imply that FIFA can or should also govern employment law matters. And we think that the Diarra judgment supports this view. I believe moving forward that player unions strongly believe that issues currently under FIFA's jurisdiction and regulated in the RSTP, the FIFA regulations, should be negotiated between player and club representatives and not be unilaterally imposed by an organization which lacks democratic legitimacy. And that brings me to my second point, which is stability. And there's contractual stability, there's stability in the composition of the team. And FIFA traditionally emphasizes the importance of contractual stability. Now, player unions have long argued that contractual stability is not a legitimate objective that is capable of justifying the very strong restrictions which are imposed on players in the name of that stability. And the unions therefore very much welcome that the court now agrees with this view. The court explicitly confirms that contractual stability is not in itself a legitimate objective, but at most one of the instruments that can contribute to the objective of ensuring regulatory of sporting competitions and comparability of results. Contractual stability is also an extremely vague term. And another important point for which the unions have advocated for a very long time is that there should only be stability to a certain degree. And the court explicitly agrees that the continuity of contracts and stability in the composition of the team is possible to a certain degree, dans une certaine mesure. That's what the court says. And this is, in my view, also a key point. The court accepts that there may be a certain stability in the composition of the team during one season. So within a single season or a competition period, point 144 of the judgment. So maybe it would be acceptable to prohibit the unilateral termination of a contract during a season, which is currently also a prohibition which can be found in Article 16 of the RSTP. But as we argued, football is not that specific that there should be a stability of the workforce during several seasons. There is no other industry that has such a prolonged stability. Workers should have the right to unilaterally terminate an employment agreement, provided that reasonable compensation is paid and that compensation can be known in advance. So basically, FIFA has enacted a set of rules which are very nicely marketed. Stability of contracts, worker protection, stability of the composition in the team. But the court, I think, in Diarra has perfectly well understood that under that layer of marketing, there is a different reality. A non-poaching agreement where employment relationships are not protected, but on the contrary, are instrumentalized to serve the economic interests at stake in the business of transfer. So these are my personal high-level comments on Diarra. Happy to answer any questions that you might have later on during this panel. Many thanks.
That was literally precisely 5 minutes. That's incredible. Well done. That was fascinating. And thank you very much, and for everyone else, for the fascinating insights so far. So to recap now, we've heard from the club's perspective, broader competition law application and what the trends are there and how this fits in that, the practical applications of Article 17 and what the consequences may be, sort of looking at moving forward. We just heard particularly from the union side, and about the focus on sort of what this means from an employment law perspective and the importance of collective bargaining, potentially the growing importance of that. And now we're going to come on to Andrea, who's going to again bring us back to sort of, like, I believe, and then Anton as well, to set sort of what's really going on, what's this broader trend that Sinziana sort of touched on as well. Andrea, over to you.
Thank you, Sean. Hello, everyone. My name is Andrea Cattaneo. I'm a senior lecturer at Yale University in the Center for Sports Law Research. When I was trying to find the publication for this judgment, and I was reading some of the comments, there were two factions. There was the faction that was saying that FIFA had been defeated and the entire system was collapsing before our eyes, and the other faction that was saying that only 2 paragraphs of the regulations have been changed and nothing really changed. I believe that the truth is obviously in the middle. But I think that there are some reasons to believe that governing bodies can be somewhat optimistic, but with a good level of caution. Optimistic because if we look at the 3 judgments of last December and this judgment, there's a line, and that line recognizes the regulatory power of governing body and recognize that exercise of regulatory power is legitimate and justified in many aspects. Governing bodies are able to regulate their own sport, and even some aspects of the sporting industry, let's say, they are inherently connected to the core economic activity of the stakeholders, such as the transfer market for clubs and players, and if we refer to the ESL, the organization of events. And so just like authorization rules in principle were a legitimate means to exercise this regulatory power, also the rules that impose transfer windows or that aim to prevent unilateral termination of a contract without just cause are in principle acceptable as a means to achieve the legitimate goal, which is guaranteeing the regularity of the competition, the stability of teams competing in championship, or the protection of the sporting merit. These rules have not been criticized per se, but what has been criticized is the disproportionate effects that the current version of the rules have created in the industry and in the market. The rules fail the proportionality test, but before and until then, governing bodies maintain a broad level of discretion in defining certain objectives and deciding the means to pursue those objectives. And this leads me to the question of proportionality and the assessment that was made by the court. This was mentioned by Sinziana before. It's interesting to me that in the ESL and the other cases decided in December, there was some room for the national court to assess the proportionality of the restriction imposed and the efficiency in some extent that the restriction created, although the court gave some clear indication. In the RI, in my reading, the assessment is much more stringent. At paragraph 104, the court says, subject to verification, which is for the referring court to carry out. These rules appear to go in several respects beyond, and in some cases, even far beyond what is necessary to attain the objectives. It then adopts a similar language when it carries out the assessment under competition law. So the court, in my opinion, leaves essentially no room for an assessment of the national court on the proportionality that departs from the one made in Luxembourg. The court doesn't suggest an alternative, which is not unusual, but it's completely up to the governing bodies to come up with a solution that addresses the various concerns that are raised in the judgment. This, again, confirms the regulatory power of the governing body that are tasked to find a solution which is likely to be quite complicated, but is also a reminder of the role of the Court of Justice, that is not the one to regulate sport or to dictate the development of sports, but is to check that the regulation of sports and its development does not infringe the fundamental freedoms protected under the treaty. And finally, the court has demonstrated that it is willing to assess the legality of essentially all sporting rules, with a very limited exception that is also debatable. This is a powerful warning issue to the governing body, to my opinion, much more powerful than just removing some elements of Article 17, because this judgment, and I'm including the 3 judgments in December 2023, emboldens the stakeholders that when they're facing rules that are detrimental to their interest, they can challenge these rules before the national courts or by filing a complaint with the Commission, as it happened recently, in the hope that the case will reach the Court of Justice. And so the effect, as it was already mentioned, could be that governing bodies should probably rethink their strategy and consider a more effective way to incorporate stakeholders in their decision-making practice to avoid litigation, which might be slightly going beyond simply a discussion, but an involvement in a co-decision type of structure. This was not mentioned, by the way, by the court, and this is just me reading between the lines. So to conclude, FIFA and other governing bodies have a legitimate claim to regulate their sport, to pursue objectives, and decide the means to pursue that objective. In doing so, they're reminded by the court of their limits and the power of the courts that bit by bit can force reform of sports governance through challenges by stakeholders. So this
Brilliant.
concludes my contribution. I'm happy to get any question if there are.
Fantastic. Thank you very much for that. And again, for those that are joining us late, please do feel free to introduce yourself in the chat. Great to see you all. If you've got questions, we're going to come on to those shortly after Antoine gives his perspective on things. So I've seen there's some brilliant ones in there already. Use the Q&A feature. I think some people might put their hand up. Thank you if you did, and you're patiently waiting. If you did want to turn your microphone on, I'll try and come to you, but we'll take the questions that are written out first. That's okay. But Anton, so we've just heard from Andrea, from his perspective. What do you think, from your perspective, what do you think is the most interesting part of this particular ruling?
Yeah, well, let me get a chance to introduce myself a little bit, just also to situate my perspective. I think it's important to understand that we are all speaking from a particular position. I'm speaking from the position of an academic. I'm not a part and parcel active on that market, nor in the football industry. I'm an observer and an external observer. For a long time, I've been writing on the transfer system. You can obviously find my publications. I'm happy to share them with you if you're interested. And let's say that I have a quite radically different take than definitely FIFA, and here presented by Mario, Ecker's take on the judgment. But I also think FIFA in underplaying the impact of this judgment is dangerous. And it's dangerous for clubs as well. And I think Mario is right that it can be also dangerous for certain players. If you want to understand the impact of this judgment, you need to first understand what is a transfer. And that's actually quite complicated. If you ask someone in the street, they will just treat players as, goods, a house. We're just selling players on the market. Well, that's really not what is happening here. What is happening when you have a transfer is the new club paying the old club to not pursue the player for breaching his or her contract. That is what is happening. So the incentive of the new club to pay the old club, so the existence of the market, depends on the risk faced by the player and the new club when a contract is breached. And that is why even though it is attacking only two provisions. Obviously, any EU lawyer knows that the Court of Justice could only answer the question. So it was always going to be about Article 17 and Annex 3. There was nothing else that could come from the judgment. But those two articles, those two provisions of Article 17 are crucial. Without them, there is no transfer market anymore. There is no reason for the new club to pay the old club. The existence of this market depends on the risk that is faced by players. So that's in particular the financial sanctions, but also the sporting sanctions. And there, sorry, Mario, bad news. I mean, they were not discussed because they were not raised. But the sporting sanctions would face similar objections, and I have very strong doubts that they would survive both under free movement and EU competition. So those two I would be assuming that sporting sanctions and the financial calculation of the damages owed are two crucial points why players are not breaching unilaterally their contracts, are not doing the same as we are all doing when we are on fixed term contracts. We are also, you always owe damages if you breach a fixed term contract. The difference in sports is that you risk much more. You risk a much higher amount in damages and you risk sporting sanctions. And in addition, what is very specific to sports and is actually beautiful if you think about it, that we have created such an exceptional system, though it is a bit at the expense of the players and creates a kind of financial bubble, is that the new club hiring someone who breached a fixed-term contract is also responsible for the damages and faces sanctions that are crippling potentially for its sporting competitiveness, not being able to recruit new players. Hello, if there are some fans of the FC Köln, I'm pretty sure they are looking into a way to get damages from FIFA. So this second aspect, which is also attacked frontally in the judgment, means that the new club has a lot of disincentive to recruit a player that has breached unilaterally his or her contract. And this is gone if the presumption is gone. It's going to be extremely difficult. You will need a lot of evidence to prove the involvement of the new club. And still, you will need to show that the recruitment sanction is not disproportionate, which I personally would doubt. So my point has been, and when I've commented about the judgment, is that we have FIFA and the clubs and FIFPRO need to accept that the transfer system as we knew it is gone. And it has immense consequences. And not all of them are good. I mean, the transfer system was a super effective redistribution mechanism from the Premier League to the rest of the world, the Premier League and now the Saudi League, to the rest of the world. Mario is right when he's saying that if you are a Dutch player playing in a Dutch club, this is not necessarily good news for you. I mean, the Dutch clubs were earning in transfers more annually than they were bringing in terms of broadcasting rights. We have to understand the situation. Economically, the system was a redistributive system. It was its main purpose. It was never contractual stability. Actually, it was organized contractual instability.
So Antoine,
it was to make
sorry, just
contractual
to be fair
instability a way to make money. So let me wrap up, and then I will wrap up. So we have a system that had a function, and now we need all stakeholders, but in particular the players' union, because they are really central in the judgment, to come to a new agreement to create rules that satisfy the players, that do not put them at certain risks, and at the same time that provide for the type of transnational solidarity and redistribution that was achievable through the transfer system. And it is more urgent than ever.
Thank you very much for that. And just to say that one could argue that the transfer system was super effective in some ways, but obviously the reason we've got the FIFA clearinghouse and all the data showed that in terms of redistribution of funds to whatever training clubs wasn't that very effective. So my point is, I'm not disagreeing or agreeing. I'm just suggesting that, you know, this may have sped up some focus on the effectiveness of the objective of the transfer system. Right. No one wants to hear my opinion, so I shall stop there. We have got some questions, but before we do, I wondered, Mario, did you want to come back in on that first, and then we can have a bit of a discussion?
Yeah, no, of course. I fully understand what Antoine is saying, and from being an academic, it was a very practical response, if I may say. I think that the point being that to say that the joint liability and 17.1 were the only factors for which transfer fees were agreed, I think it's a bit reductionist. And it's a bit reductionist in the sense that you have two aspects. One is the sanctions. I mean, I know that you say that according to you, if it will be challenged, it will also not be upheld. Okay, that's a purely hypothetical point, right? I mean, we're dealing with the judgment as is now. And the judgment as is now doesn't touch, one, sanctions against the players, and the sanctions against the clubs. That I say, I don't read this as being unlawful as a principle. I just read it as being the way that it operates, it doesn't work. So you need to come up with a solution where it's actually the inducement that is punished. Now, I understand your point that from an evidentiary point of view, it would make it more complicated, but it doesn't make it disappear. Now, in terms of sanctions against the players, I wonder which club would actually want to sign a player that will not be able to play for 6 months. I mean, there is no rational, in my view, business decision for which a club would actually get a player knowing that they cannot benefit from him from 4 to 6 months. It doesn't simply work that way, because a player that doesn't play for 4 to 6 months, then at the end of the day, their level is reduced considerably. So that is what I'm saying, and that's the first point. And the second point that I wanted to say is the transfer market has always operated in a way where clubs understand that they all benefit from a transfer fee, or for a hierarchical pyramidal transfer fee system, right? Where the big clubs pay the small clubs. Now, obviously, this can get affected if clubs think that they can recruit players easier. But I still think that clubs will realize how damaging it will be for everybody if suddenly just the best players are starting to be concentrated against a handful of clubs that can actually play the salaries. That's what happened in Bosman, no? In Bosman, what happened was that in a way that the concentration of players focus on the clubs that actually pay salaries, right? Because at the end of the day, if I don't receive a transfer fee, I'm not going to pay salaries. So the clubs that can't pay salaries are the big ones. So that's going to lead to a concentration of talent. And that extreme concentration of talent, don't think that benefits anybody. So I do think that while you can argue, and I don't disagree with that it may lead to breaching contracts more, they're more being incentivized to do that. I think in the long term, clubs will realize two things, at least as things stand now. One, that it doesn't make any sense to get a player that cannot play. And two, that the system as it operates now is not only beneficial for the big ones, it's beneficial for everybody, for training clubs, as Sean was saying. So that is why, in our view, even though we recognize that changes will need to be made, I don't think that this judgment in and of itself causes the dramatic consequences that you are portraying. Now, it will cause consequences. I'm not saying that it wouldn't, but not as dramatic and in the short term as I think that you are emphasizing.
So, Anton, have you guys got a quick response? Because then we've got loads of questions that we're going to need to.
I think this warrants a bit of a discussion, because this is really the interesting stuff that we're looking for. No, I mean, I think there are two aspects to your response or to your reply. Is on the one hand, basically holding on the sporting sanctions, to hold on to something that creates enough risk to have a transfer market. Again, I think this is hallelujah. I mean, good luck for that. But I'm pretty sure there are many good lawyers that are already looking into helping certain players get out of their contracts and are ready to threaten. And I'm not sure FIFA would take the risk. I mean, financially, it would be a huge risk for FIFA in terms of liability, because the players would suffer harm and they would then be entitled to compensation, such as Diarra now. So I do think that, unfortunately, even that is gone. And I sympathize a lot with your point about solidarity and redistribution. But I think this new response misses the point. And the point that was made already in Bosman by Advocate General Lenz. The Court of Justice, the European Union, has always been in favor 100% of redistribution from the rich clubs to the poor clubs, from the rich leagues to the poor leagues. The point has always been, and I really encourage you to reread the Advocate General's opinion, has always been how we do it. Do we do it through this transfer system that is extremely arbitrary? There is a redistributive dimension, Sean, but it is extremely arbitrary, extremely disconnected to actually training and so on. Or do we do it differently? Do we do it through a proper redistribution of broadcasting income?
So Anton, on this, I think it's a good, thank you for that. I think the other thing to mention, and Peter, you brought this up earlier as well, I think, when just as we were coming in, because I wasn't aware of it, but FIFA have asked obviously for a global dialogue on this, and have acknowledged the fact that they do need to consult with stakeholders. To what extent, I'm not sure, but they've at least had the public call for that. And then, Peter, I think you were saying just before we just jumped on, if that's correct, that they've also put out a request for FIFPRO to consult on this. Is that correct, Peter?
Yes, that's correct. And there's also a new web page which has been made available today, where everybody can voice his or her opinion on the implications of the Diarra judgment before the 15th of November.
15th of November. Well, hopefully this session will be included within that. If not, someone can submit when it goes on YouTube. Someone can submit it. Right. So one of the questions which I think has been touched on, and I'm going to, and again the speakers can see the question as well. That the one person asked, and I think it's been brought on a couple of times. Sort of, what do you think the wider implications are for other sports also? Peter, you've said right, we need proper collective bargaining from an employment law perspective, particularly within football. But do you think that extends to other sports as well?
I think so, yes.
Yeah, and for everyone else, yes, Sinziana?
Yes, there is actually no reason why it shouldn't apply to other sports in the end. I mean, we're speaking about football because football is relevant from an economic point of view, but there is absolutely no legal reason why it shouldn't apply to water polo and handball in the same way, to the extent the rules exist in those sports. And we need to be reminded that football is just one type of sports. And
this was the case, as Andrea said, with the previous decisions. You know, I remember, I think it was Benoit Keane saying, look, this doesn't mean pre-authorization rules in the European Super League case are out the window, but they just need to be visited as a call to action for other governing bodies and regulators to do that. We've got a question from Namit Akalandi. I understand that since the presumption against the new club is now challenged, older clubs will need to create more watertight penalty clauses, which, as mentioned by Carol, would also national laws come into play more now, especially that the Swiss code provides for similar structure of penalties. So maybe this is a question for Carol, Peter and Mario.
Yeah, there's reference in the judgment, isn't there, to certainly under Article 17.1 of actually, whilst national law is referred to in that, so that the FIFA body should take into consideration national law, actually FIFA's approach to date has been to take a really harmonised approach to all of these disputes, because their stance is we are the global regulator and therefore there should be a harmonised set of jurisprudence. Wherever you are in the world, you should know what the FIFA regulations and the FIFA jurisprudence provides for. Now, if there is growing importance of national law, we are going to have very different solutions depending on what the issue is, because the situation in Argentina under employment law will be very different to that under Belgium. And so we're going to have a very fragmented approach to kind of contractual disputes.
And for background, that's one of the things that a lot of people don't realise in a sports context, but particularly in football, there are many places in the world that players aren't employees when we're talking outside of Europe, and that's something that FIFA have to kind of address. But Peter, should we go Peter then Sinziana?
Yeah, two brief observations. There's a reference in Article 17.1 to national law to calculate the compensation. In the FIFA commentary, it's explicitly said that the national law is in practice never applied. And this was an important element why the court decided that Article 17, the way compensation is calculated, is disproportionate. So that's first observation. Second observation is, and Carol is rightly pointing to that point of the judgment. Why do you need Article 17.1 if you have national law? And that's also a point which has been taken, a consideration which has been taken into account by the Court of Justice. Why do you need, on top of national law, a FIFA system to calculate compensation if more proportional compensations can be calculated based on national law?
Thank you. Sinziana? Oh, sorry, and then Mario, sorry.
No, Sinziana can go first, and you can go on that, yeah.
I agree with both Carol and Peter there. I think the point that the Court of Justice was making was that this rule with national contractual law was in practice never applied. There is a way to achieve more harmonization on a contractual level by agreeing the application of, for example, Swiss contractual law, but this is something that would need to be agreed like on an individual basis. So I think there a bit more harmonization can be achieved, but then again, it will depend on a case-by-case basis.
Thank you. Mario?
Yeah, no, I mean, what I want to say also there, actually, what Peter was saying at the beginning, I think it's very risky, actually, for the players to take the stance that FIFA should not regulate employment matters. Because, I mean, let's remember, 17 not only covers the compensation due to the club, right? It also covers the compensation that is due to a player. And it covers when a player can terminate a contract. And it covers other stuff, the dispute resolution system. So if what we're saying is that FIFA cannot regulate any employment matters, what's going to happen now is that when a club doesn't pay a player, good luck the player suing the club in the Turkish courts or in the Saudi courts, right? So, I mean, we have to be very careful also because, for instance, under Mexican law, an employer can fire an employee if he misses 3 days at work without justification. Now, what we're saying is that would also be valid now if what we are saying is that national contract law is the one that will apply. So I think it has to be very careful when we say that FIFA should not regulate employment matters, because in the long term, I think the most damaged party on that will be actually the players. Now on CBAs, I'm not an expert by any means on EU law. I don't know how exactly it works in EU law, under EU law, but I can tell you that in the Americas, it's extremely difficult, say maybe in the US, that it's way more common, that CBAs are actually agreed. Now, I know that, I mean, I work in an organization that has Europe in the name, so I know that we are very tend to look at things from a European perspective, but this is way wider than Europe. So I think for any kind of solution that we think will benefit the entire system, we cannot only look at what is beneficial for Europeans. I think we have to make a balance. Obviously, it has a big impact and it has a material weight because where FIFA is. But I think that's only one piece of the puzzle that needs another way of considerations to assess.
Mary, on this point, though, Miguel Anza basically asked that could we get a European Pacific collecting bargaining agreement so it would only apply within the European Union? Do you think that's a likely course of action? So we kind of end up in a situation with transfers of minors, for example.
Well, I mean, you have, for instance, the social dialogue platform where some agreements can be reached in national level. So, I mean, for a specific kind of markets, for specific topics, I think it can work. But again, from a non-European perspective, that it's slightly alien to me, I just don't see how you can get a harmonized system on a worldwide basis on the basis of CBAs. From a practical point of view, it's difficult for me to see it, to be honest.
Okay, Anton, so you've been patiently waiting. Thank you.
I think Mario makes some good points in the sense of the players have also an interest in their STP, it provides also certain labor rights transnationally that are not necessarily provided in the national law. And that's why I'm quite confident, actually, that there will be a negotiation where different parties are going to agree to a compromise. I don't think the compromise can revive the old system. I do think that the time of a kind of totally free market where clubs were free to negotiate the price of the breach is gone. But I think there are ways to accept for FIFPRO maybe in negotiation to engage on the question of how, again, to calculate the compensation owed that would be different, but that would still allow for some type of transfer fee to have to be paid. So I think there is an opening in a sense that there is also an interest in FIFPRO in maintaining to some extent the system. Though I do think that I don't see anything blocking a CBA, a collective bargaining agreement, at the global level between ECA, FIFPRO, and then or at the European level. We could have a separate transfer system that would not be really a transfer system, but a separate labor law regime for football players at the EU level. And in a way, this exists already in the US, as far as I know. Yeah. So there is through a CBA. So there is actually no real complexity in that. It would fragment further the transfer system. You would have different rules applying to different players moving to different countries, but it wouldn't be impossible. And I think it is one of the realistic options for what will happen next.
Thank you for that. And I'll come to Sinziana. One of the things I was going to just mention an observation, I wrote it down when everyone was talking earlier, that it seems that from what everyone was saying, that sport as it's evolved, particularly football, but other sports as well, have gotten away essentially with using vague terminology and vague objectives, right? We're avoiding that sort of clarity of discussion and engagement, right? To get things moving. And it seems to me that that's the real shift that you guys are articulating, is that we have to be really precise as people in the sector about what is the intended objective, what are the economic consequences, what are the real impacts, and a bit like, you know, we're doing these sort of environmental impact assessments, as we're seeing more on the ESG, the environmental social governance side, being really clear. And I think maybe the you know, now that there is more transparency generally, people are becoming more aware of that. So Sinziana, you were nodding away then. Sorry if I've said something that you were going to say. But
my only observation on the CBA is that it needs to be designed in a way that it cannot be considered a circumvention of antitrust law. I think that this was the question at origin, that, oh, we should avoid the application of antitrust law because it doesn't apply to CBA. That is correct. But equally, if we just do it to avoid the application of antitrust law, it will not hold in court.
Thank you for that insight. Borja.
Muted? Yeah, I was muted. No, I just wanted to make a couple of comments on observations that perhaps could spark ideas of debate. Having heard everybody, I'm certainly not going to make it in the technicalities of EU application of EU law, but it does seem to me indeed that there is a validity in the point that I'm not entirely sure relying on national employment law is such a good thing for all players, for all football players. It might be for some, but not certainly for others. And then that might lead to certainly 2, 3, 4, 5 tiers of player welfare, which I don't know if the trade unions are really happy with that. Plus, it may well lead to issues of that we've seen also of dumping, basically, not fiscal dumping, but condition dumping. So okay, now all of a sudden Italian clubs, it's more difficult for players to breach their contract in Italy, so therefore they are going to avoid Italy. Well, whatever. I think that is not entirely sure that is that is such a good thing, because the labor market in football is far more globalized than in many other professions. I do think the labor market, for example, is very similar to the one of pilots, for example, so where there is a small supply of people with high expertise. But of course, I don't think that one of the pilots has the the global nature of it. So we need to take that into account. And then in terms of but at the end of the day, I think that really if we want this to be stable, there needs to be a negotiation between employers and employees. And I think the problem here is that the system is structured in a way in which FIFA is creating rules, but of course is creating rules on behalf of the clubs and the players, and therefore I'm not entirely sure FIFA could be the forum where those two social partners but there needs to be those are the two that they really need to get agreement if we want stability and legal certainty. That's the thing to me.
We've got a couple of questions that I'll come to that lead on to this, but one of the things, we just did our global summit a few weeks ago, and the one thing that we heard about, even when there's collective bargaining, there can still be lots and lots and lots and lots and lots of litigation, right? So it doesn't necessarily avoid that. And at the moment, there is a lot of litigation in world football at that level between FIFPRO, World Leagues Forum, FIFA, and other things. So to try to create an environment that leads to conductive negotiations, that seems to be a hurdle that needs to be overcome quite quickly. But Peter, come to you and wondered if you could at the same time give us an update. We got, and I'm going to apologies, I'm going to say the name wrong, I think, Tijin Francis has asked, when do we expect a decision from the Belgian court? So maybe.
That's a question from Stan Francis.
Sorry, thank you, and apologies then.
Just some other comments. So I think we all agree that a new system must be set up, and we need to find a balance between the interests of clubs and players. And I think the ideal solution would be that clubs and players sit together and find a compromise, which is then maybe should be then accepted by FIFA, endorsed, represented by FIFA. As far as the CBA at European level is concerned, I agree with Antoine. This should be possible. The social dialogue is a good start. Article 152 of the EU Treaty provides a regulatory basis, I think, to start collective bargaining negotiations at the European level. And then coming back to the question of Stan Francis, when we will have a judgment of the Court of Appeal in Mons. Now, the case is now referred back to the Court of Appeal. The Court of Appeal now has to organize the procedure. We'll invite all the parties to submit written briefs. It will also a little bit depend on what FIFA has to say in those national proceedings. Will they nevertheless try to justify the rules in the RSTP or not? Then the court also has to take an important decision on the compensation, which might be due to the player. So I do not expect that we will have a judgment of the Court of Appeal within the next 6-7 months.
And do you think, again, a great follow-on question from the same person, what happens if we don't reach an agreement, if there's no agreement between FIFA and the player union before that date? So
that's a very good question. And for me, there are also some strategic decisions to be taken by FIFPRO. It's very difficult for me to comment on this one.
Okay, thank you. Andrea, and then we've got a question from Stephen Ross.
Yes, thank you. I wanted to say something about the social dialogue that has been mooted as a possible solution. There is currently, a social dialogue committee that should still be active in professional football that has produced a minimum standard agreement for contract, but this is very minimum. And as my understanding, that one of the challenges was to involve also member states, because social dialogue at European level is then endorsed by the European Union with a form of measure that then is distributed to member states for application. And in the case of social dialogue, the distribution didn't really create much momentum. And so if the idea is to involve the European Union, which to a certain extent has standing as an idea, because we remember that the 2001 agreement between the Commission and FIFA that started off the whole new transfer system, then there's also need to involve to a certain extent member states that needs to put their weight behind any type of measure that comes out of the social dialogue to give effectiveness to that type of agreement.
Thank you. Antoine.
Yeah, let me add. I mean, there are options for formal social dialogue. The other issue is that in any case, even if FIFA, the clubs, are not able to find an agreement that is formally called a collective bargaining agreement, the court's position is, I think, quite clear on the fact that if FIFA engages through its own private regulation in the regulation of labor, which is the core point of the RSTP, it needs to take in account the view of the employees. And that means that there is no new RSTP that can be negotiated without a proof of the employees having had a say in it, be it called a CBA or be it called whatever else, okay? It doesn't really matter at this point. A CBA would have, I think, the advantage of being negotiated directly between the clubs and the players and be fitting into the Albany exception to competition law, but still be subjected to free movement rights. So the free movement question would still be posed. As you mentioned, there will still be room to challenge as well as CBA. I mean, there is nothing that a lawyer cannot challenge. They're there, we're there for that. But it would be much more difficult. The point of FIFA is now to build a new system that has, in the eyes of the court, and I think, I don't know who mentioned it, but the whole string of cases of the court in the past year are mainly about bad governance in sports, that in the eyes of the court has legitimacy. To gain this legitimacy, it needs to be the product of a process that is not only looking like you're consulting. So we will see what this new consultation gives us, but that is actually giving a real voice, a real power in the decision-making to the ones that are primarily affected by the rules, in this case, the players. So I think we have to come to terms with the fact that this transfer system is gone. It poses a number of problems also to players. Now opens up a phase of negotiation. And in this negotiation, the players will have a strong voice. If they don't, then the new system will be on very, very shaky grounds, and we are back again at square one almost.
So I guess there's a question. I've got a question with this though, right? So in this system, right, the court's made its ruling. It goes back to the Belgium court, right? A bit like when we had with the agents case, where we had to pull certain provisions. What do people think happens though? So if you're saying that this dialogue, as the dialogue's taking place, for example, what goes in the interim period? So if we've got the current system at the moment, which has been criticised and says, right, this is now unlawful without collective bargaining or as a consultation, what happens in the interim period? Because this could be a rather long drawn out process. Or is that, Peter, you put your hand up instantly for that. So I'll go to Peter, if that's okay.
I think a number of principles are now clearly established. And so something which we very strongly emphasize in the proceedings is that under no circumstances it is acceptable that as a compensation, a player should pay the lost transfer fees or the non-amortized transfer fees as a compensation. And so there's very strong language in the judgment of the court, which says, well, this has nothing to do with the employment relationship. And under no circumstances whatsoever, it's possible that a player can become liable to pay these kinds of fees as a compensation when he or she unilaterally terminates an employment agreement. So there are a number of important principles, which I would say are almost set in stone now, even though there's still a decision to be taken by the Court of Appeal.
Got it. Thank you. I think I got it. Borja. Then Carol.
I do have a question for the panelists. Really, I had other comments.
Can we go back to Carol first then to just comment? Sure. I think she had a comment, then a question,
sure.
And then I've got a follow-on question from Steve Ross on the same point addressed to Peter, which I'll come to. But then I'll come back in for you, Borja, on that. Carol.
Yeah, I think it's linked to the sort of joint and several liability point. And whilst the court's critical of that principle, in a sense, whenever I've seen this work, ultimately, if a player is liable, whether as a principle of joint and several liability, the club is therefore liable, or in practice, the new club effectively indemnifies the player for whatever damage is due. And I appreciate there will be some players that don't have a new club to go to. They are on their own. But I'm just, as a point of kind of industry practice, I do think this happens so that actually the new club, in effect, indemnifies the player, and that's just to take into account the reality.
Yeah, and that's very similar to other industries, right? You see in finance, in banking, when they say, right, okay, you've got a non-compete clause, and then someone else induces them to join them, and they normally reach an agreement, don't they? Right, it's in a settlement agreement of some sort. Peter, you want to go then, Anton?
Something I want to add. So as part of our written observations, we also explained to the Court of Justice how these rules were applied in practice, mainly by Couse. And so we submitted copies of the Mathusalem case, the Sanctis case. There's also a famous case, Anderlecht versus Suarez, where the Suarez was held liable to pay the replacement value of the player because he left unilaterally. And so there's also a reference in the judgment of the Court of Justice to how mainly Article 71 has been applied in practice by CAS, and the court clearly says that such an application, such an interpretation of the rules is no longer possible. That's something that I wanted to add.
Thank you. Anton?
Yeah, maybe on your question, what happens now? And I think it's a crucial question as well for the practice. What happens now is, on the one hand, we could see in the next transfer window, players breaching unilaterally their contracts and joining new clubs, which FIFA cannot do anything about in the short run. There will be maybe a claim for compensation, and the new club, instead of paying a transfer fee, would pay in front a big signing bonus that would, in a way, be paying the player for his risk in terms of facing the damage claims. So that's probably the new way the transfer could operate. The second potential immediate consequence on the transfer market is a freeze. Clubs being unwilling to invest on the market because they are uncertain about whether they hold an asset or not and the value of it. So clubs will have an incentive to not necessarily move on that.
Sorry, on that, Anton, a great point. Just to add into that, someone asked a question on this, which is I know some people will be thinking about this, which is the influence on business models. So we're seeing a lot of investment in football. Some of that investment, particularly in the sort of mid to lower tier, has been on the basis of being able to train and sell players. And so you just identified there how that might impact on that. So
let me finish with my third.
Yeah.
The third is that if there is litigation, if there is a dispute, it will be primarily brought under national rules, national labor law. So there will be a lot of potential work for labor lawyers out there in this context. And then what is the impact on the business model? Well, a lot depends on the new system that comes in. We don't know yet. But under the current situation, the whole trading business model is gone. Right now, it's paralyzed because of the uncertainty of the value of the assets that are held. And in general, again, the decision of the court attacking Article 17, and Article 17 is the entire transfer market, is basically putting down, I would argue, the idea that you can speculate on that market easily, because the court is demanding that the damages be predictable and be limited to reasonable amounts. And if they are predictable and limited, there is no transfer market anymore. There is no reason to negotiate a big fee. If you are doing that as a club right now, you are just doing charity for the other club, which is nice. And it might be great if the Premier League club would continue doing it. But at this point, this is mainly what would happen if there is a big transfer in the transfer window from, let's say, a club on the continent to the UK for a big transfer sum. So this is it has massive implications. Again, I'm trying to ring a bit the alarm because I'm a bit worried. It has massive implications for the economy of football. And football needs to come together very quickly to figure out how to deal with it.
And so do you think, so you've written on this, and someone referred an article that Professor Jeff Parsons wrote, wrote many years ago on the transfer system, I think again 10 years ago, basically saying if you look at the objective of the transfer system and the redistribution of developing talent, there was a lot of assumptions that were made in that don't stand up to objective justification. Right, when scrutinised, it does feel like there's a peeling away bit by bit of this, and so you're suggesting that we need a really radical rethink of this. So in this consultation, it'll be interesting to see, and I wondered what the panelists thought. Again, someone's asked this, what they thought of FIFA's response to this at the moment, and what does that mean? And then Carol, maybe you can come in on that as well at the same time.
Yeah, first of all, in terms of the response, I think there's clearly a willingness to consult. Obviously, we've had the Football Stakeholders Committee, which had been in place to deal with various issues. My sense is that perhaps that needs that, and the structure of that perhaps needs revisiting. But yeah, a really thorough consultation. But I think possibly not just on this. I think there are other areas of the regulations that might be subject to challenge. I take the example of the loans restrictions. Say we've got the restrictions on the number of players that can be loaned between clubs now. Clearly there are some justifications for that, but has it gone further than it needs to, and could that be subject to a challenge? There are various things within the regulations which could be revisited. Also, kind of the redistribution, solidarity, training, compensation, is it fit for purpose? Does that actually just need revisiting again? So is it more than just this? And just the other point that I was going to raise, just in terms of a practical fallout potentially of this, if ultimately kind of the sanctity of the contract is under threat, what I do see going forward is perhaps more of the loyalty-based payments being made on playing contracts. We see it a lot anyway, but I wonder whether actually we'll see kind of that backloading of payments. So if a player stays through a period of time, through the end to the end of a season, are you going to get really significant bonuses being paid to kind of incentivize them to stay rather than to move?
Which is, if you look at the American CBAs, they've got a lot around that, right? As in, you bring in a young player, they stay for a certain period of time, then they can reach their maximum contract. So yeah, we've seen that type of behaviour elsewhere. Brilliant. I'm very conscious of time. And I've seen there's some brilliant questions there. And forgive me, we're trying to cover a lot. I think hopefully you agree with me that the speakers have been absolutely fantastic. Moderation maybe could have been better, so apologies for not getting to more questions. Maybe a 6 out of 10, but sorry for that. Inevitably, we knew we were going to get lots of questions, but hopefully we've addressed them. I'm just trying to look through a lot of them. I think some things that, and maybe there's some final thoughts on this about what do we think the impact will be on transfer of minors. I know there's been some certain questions. Undoubtedly, there's going to be some questions about the roles of lawyers. I think we've just agreed now there's going to be more involvement, particularly being more precise on the employment advice. But I wonder what people think will happen in the short term, and particularly, will this have an impact on minors, so under the age of 18 and below? Do you think this is going to have any immediate impact on that, Carol?
I mean, it's one of the points that the judgment actually makes, and it refers to, actually, whilst things happen in practice, unless they're specifically provided for in the regulations, then ultimately there's nothing for FIFA to hang its hat on. So one of the points there is there's the provision about players being able to move within the EU, EEA between 16 and 18. But actually, in practice, what happens is those that hold EU nationality can also move outside the EU to within the EU EEA. It's not provided for in the contract, and so again, I don't think, you know, if that were challenged, sorry, it's not provided for in the FIFA regulations expressly, and I think if that were challenged again, you know, can FIFA just rely on its jurisprudence to say that happens in practice? I suspect not.
Thank you, Anton.
Yeah, I mean, that's the question of the free movement of minor, and again, the compatibility of the other provisions of the ERSTP is a question for another day. But that is why I've always found a bit ridiculous the FIFA trumpeting the fact that the rest of the ERSTP is standing. Yeah, obviously, it was not contested in this case, so there was no way to test that. That would be for another case. But I do think there is a direct implication for minors. If the trading model is gone, then obviously a lot of clubs will have much less incentives to actually move players at a very young age into their academies to try to groom them into being potential sellable assets. So that is one potential consequence which would diminish the demand of the market for very young, promising players. In my point of view, from a policy perspective, not necessarily a bad news. But this is really dependent.
Yeah, thank you, Anton. I'm just conscious of everyone's time. No, Anton, you want to say? Sorry, Andrea, you want to say one more thing before we close off?
Yeah, just to on this point, there's an overriding interest here that is the protection of the minor, because we said that the breach of contract can occur for the player but the club as well. And so Antoine said, what is the incentive of the club? Well, the club can essentially decide, right, I'm not going to invest the player, I'm going to terminate the contract with the player, and if the player is a minor, is then left to his own or their own, essentially. So there's an interest that needs to be very carefully seen in this reform, that is the protection of the minor as well.
Borja, is it a final remark, or because we've got to be short? Because
no, very, very short. I only wanted to share, being the only Spaniard in the panel, the lessons that we could draw. Something like that happened, of course, in Spain quite some time ago, when the government introduced legislation allowing professional sport people, professional players, to breach unilaterally their contracts with the clubs. That was done in 1986, actually, as a result of a series of strikes by the professional football players. The response of the industry to that was to move all that relation to the contract. So hence that's a lot of people always ask me, oh, why in Spain do you have buyout clauses in your contracts, whereas we don't have it in England? It was basically because the government introduced regulation, and what the industry did was to move it to the contract. So I think another step to look at to what is going to happen in the next few months, to what all the others have said, is the extent to which all these relations are going to start moving to the contract. So contracts are going to stipulate buyout clauses, reasons why the contract can be breached, etc., etc., etc.
Thank you for that. And again, it is, I guess, another thing to take into account, that we don't want to make this more and more complex, in the sense, because this adds more and more friction, right? It needs to be done in a sensitive way, I think, which is the point, that is in a thoughtful way, which is a point that's been made by all the speakers. Kylie Sondi made a really good point about the impact on competition law in the UK. I'm sorry we couldn't get to it. We'll cover it off in an article at a later date. Other than that, thank you for everyone for being with us today. Thank you all for your fantastic questions, for everyone for putting in the chat. Again, thank you to Sport and EU and to the Asser Institute for your great work, and you continuing. Again, we love people that do stuff publicly and help people to understand. And of course, we really appreciate our speakers who have given up their time to do this. They've done it freely. No one's paid to do it. You know, they've got other things they could be doing with their time, but they recognise the importance of creating greater clarity in the sector, which we all benefit from. So thank you for all of you speakers for giving up your time. And thank you to Manan, my colleague, and other colleagues as well, but particularly Manan for organising this. He put a lot of hard work into doing this, so we really appreciate it. And if you did enjoy it, the one thing we'd ask is please tell people about it, share it with people that you think would find it useful. That really does help make sure that we have a better dialogue and better narrative amongst the stakeholders, and of us as sports fans, as football fans. We are part of that stakeholder movement as well. So thank you all very much. I hope you have a wonderful rest of your day. Thank you. Thank you, speakers. Thanks. Appreciate it. Bye.